Massive immigration changes in 2026 for green card holders. Welcome to U.S. Policy Brief, your reliable source for the latest U.S. immigration news. I am your host, Daniel Brooks. In this video, I want to go over the 4 major changes that will affect green card holders, whether you are currently a green card holder or you are applying for your green card. These changes are transformations that we have observed based on applications from last year, but also modifications that have come directly from DHS, USCIS, and DOS. But what I also want to accomplish in this video is not just only discuss the changes, but also how you can be prepared for these changes, how you can navigate these changes, but more importantly, how to make better decisions when you are applying for your green card, whether it's through marriage, whether it's through a family member, or just to make sure that you maintain your green card in 2026. As you know, immigration in 2026 has been off to a movie-like start. After observing immigration developments for almost a decade, the immigration system has done a phenomenal job of processing cases. In 2025, there were record approvals. So what does that mean? The Trump administration is still approving green cards. Immigration is still moving. Immigration is still one of the #1 ways to achieve your American dream, your version of the American dream. That is my goal for you today, to educate you as to how you will navigate these challenges. So let's get into it. The #4 biggest changes in immigration in 2026. So #1, mandatory entry and exit biometrics. This is a significant transformation that every green card holder needs to understand thoroughly. What the Trump administration has implemented, and there are going to be people who claim that this was always a requirement, but the reality is, it wasn't always utilized to the level that it is being utilized now. When you depart the country as a green card holder, and when you re-enter the country as a green card holder, they will be collecting your biometrics. But the critical question is, what will they be doing with those biometrics? They will be scrutinizing your travel history. They will be examining your immigration history. They will be investigating your social media history to flag if you have posted anything anti-Semitic, anything that goes against U.S. policy, anything that violates the terms of your green card. This is comprehensive surveillance that was not being implemented at this level before. I have already conducted consultations in 2026 where people have received a notice, and yes, today is the 10th of January, and I have done a consultation where someone has received a notice for rescission of their green card based on travel that they completed in 2025 in December. This is happening rapidly, and it is happening to real people who believed their status was secure. So people, if you possess your green card, make sure you understand what you're posting on social media. Every tweet, every Facebook post, every Instagram story is potentially being monitored. Of course, you cannot have any type of criminal history, right? And you have to be cautious of what you say and who you say it to. You just never know what might occur. The level of surveillance has increased dramatically, and green card holders must adapt their behavior accordingly. This biometric tracking system is connected to multiple databases that share information across agencies. When you travel, your movements are being tracked and analyzed. If there are any inconsistencies between your stated purpose of travel and your actual activities, this could raise red flags. If you have traveled to certain countries that are considered high risk, this could trigger additional scrutiny. The message is clear. As a green card holder, you must be extremely careful about your travel patterns and your online presence. #2, the increased scrutiny of marriage-based petitions. I cannot stress this enough. Marriage-based petitions will be increasingly more difficult in 2026. All right? So, the first thing that we have observed is that from the 19 high-risk countries, they have completely halted the immigration process through marriage. Countries like Nigeria, Burkina Faso, Sudan, Syria, Palestine, and others are facing complete processing freezes, and there will be significantly more scrutiny when they evaluate your case for fraud. What is marriage-based fraud? It means that you entered into a marriage for the sole purpose to evade U.S. immigration laws, meaning the marriage was not real. Of course, everybody understands that this has been a concern for USCIS for decades, but in 2026, they have significantly more tools at their disposal. They have TSA tools, they have social media tools, they have IRS tools, they have significantly more resources with which they will be scrutinizing your marriage-based petition. The technology available to immigration officers today is far more advanced than what was available even 5 years ago. They can cross-reference your financial records with your spouse's financial records. They can examine your social media accounts to verify that your relationship is genuine. They can look at your travel patterns to see if you have actually been living together. They can even examine your phone records and email communications if they suspect fraud. They have also mandated immigration interviews, right? There are no more waivers whatsoever. I mean, there are still some instances here and there where the interview will get waived, but they are now requiring for almost all marriage-based petitions that you must appear in person. And guess what, people? They don't care about excuses. It does not matter what your circumstances are. You must be living together. They don't care about if you are working somewhere else. They want to verify that this marriage is bona fide and you are living together. So marriage fraud, they're going to be pursuing that aggressively. They're going to be ramping it up, and they're going to be utilizing your lengthy immigration history from the way how you entered. I just had a recent case brought to my attention where they denied the marriage-based petition, right? Not because the marriage wasn't bona fide, but because when the husband entered the country, he made a misrepresentation when he applied for his B1, B2 visa. Yes, the case can be resolved, but this case was denied because of that historical issue. So these are the things that are happening in 2026. The way how we would fix that case is we would actually have to refile, but do it with a waiver for misrepresentation. But it just goes to demonstrate the level of scrutiny that is coming for marriage-based petitions. They are cracking down on every single area of immigration, especially as it relates to green card holders in 2026. The documentation requirements have also increased substantially. You need to provide more evidence than ever before to prove your marriage is genuine. Joint bank accounts, joint leases, joint utility bills, photographs together spanning your entire relationship, affidavits from family and friends who can attest to the authenticity of your relationship. The more evidence you can provide, the stronger your case will be. But even with extensive documentation, you should expect intense questioning at your interview. Number 3, the public charge rule. Now, some people are claiming this has been like this for years, for decades, and so on. They have been implementing this. But guess what? They rarely enforced it with any consistency. Now it is revamped, and they will be denying cases if the spouse, such as the U.S. citizen spouse or the immigrant, has once utilized benefits like SNAP, Section 8 housing, or other government assistance programs. They will be using the public charge rule to deny cases. Mind you, in 2025, USCIS officers had the most power in the history of immigration. USCIS officers were emboldened to where they could deny a case before it even gets to interview, where they could refer a case directly to immigration court at the interview, or they could have ICE directly at the interview. They have implemented that significantly more in 2025, and this trend is continuing into 2026. So, immigration officers can and will deny cases for the use of public funds. And people, yes, I understand you're going to say this has been around for a long time. A lot of laws have been around for a long time. But guess what? In 2026, they are bringing them all back and enforcing them with unprecedented vigor. The public charge determination now looks at a much broader range of factors. They examine your income, your assets, your education level, your employment history, your health status, and your family size. They want to see that you can support yourself and your family without relying on government assistance. If there is any indication that you might become dependent on public benefits in the future, your application could be denied. This means that you need to have strong financial documentation ready, tax returns for multiple years, pay stubs, bank statements, proof of employment, and evidence of any assets you own. If your income is low, you may need to have a joint sponsor who can demonstrate sufficient income to support you. The threshold for what constitutes sufficient income has effectively increased, even though the official poverty guidelines remain the same. And last but not least, when it comes to your green card renewals, the I-90, the form that you must use to renew your green card, they are expecting to hike the fees on that significantly. And not only that, they will be extending the waiting time in which you can receive that renewal. But most of all, there will be more scrutiny before they renew that green card. They're going to go back further into your immigration history, and it's almost like they're re-evaluating the validity of your green card to see if the way how you attained that green card, if it was by fraud, if something was missed during the original adjudication. And these are for people who have had their green card for years. These are the things that they will do in 2026. So number 4, it's the renewal of the green card. They will be conducting significantly more scrutiny. It's no longer just a stamp and reissue. They're going to be reopening that file in 2026 to look at your immigration history. This means that issues that were overlooked years ago could suddenly become problems when you try to renew your green card. This is particularly concerning for people who obtained their green cards through marriage that has since ended in divorce. Even if your green card was legitimately obtained, the scrutiny during renewal could raise questions about whether the marriage was genuine at the time. You need to be prepared to provide evidence about your original marriage if questions arise during the renewal process. The fee increases are also significant. What once cost a few $100s could now cost significantly more. For families with multiple green card holders who all need to renew, these costs can add up quickly, and the extended processing times mean that you need to plan further ahead. If your green card is expiring, you should file for renewal much earlier than you would have in the past to ensure you don't have a gap in your valid documentation. But what can you do with all of these changes that have happened? The number one thing that I always emphasize is that you must be prepared. How are you going to be prepared in 2026? You're going to stay on top of the immigration laws, meaning you understand them thoroughly. If you are filing for your green card, no matter if you have an attorney or a document preparer, you must also comprehend what you are doing. You must make sure you have a copy of every single thing that was filed on your behalf. And you must also utilize a professional. You definitely have to do that. Use a professional with experience. But nobody's going to understand your immigration case more or better than the way you do. You lived your life. You know your travel history. You know your relationships. You know your employment history. An attorney can guide you, but you need to be the expert on your own case. The second thing that you can do is preserve evidence for any type of green card application, whether it's through your child, from a parent, or through marriage. What drives a case now is evidence and preparation. Make sure you have everything organized. If you know you're going to file for a green card, before you put in that application, from the minute that thought comes in your mind, make sure that you are saving the different types of evidence that you think you might need. Of course, a professional will assist with preparation, but screenshots of social media, birth certificates, marriage certificates, every single thing that you think you will need, you start creating an organized folder for these things. In today's digital age, evidence is easier to create and preserve than ever before. Take screenshots regularly. Save important emails. Document important events with photographs. Create a timeline of your relationship or your residency in the United States. My most successful cases are the ones where the applicant comes in already prepared. And you might ask yourself, well, why do they need assistance if they're coming in already prepared? Because professionals can make it better and will make it better because there are certain things within years of experience that have been observed that can be added to the file that makes it even significantly more prepared. But once you bring the file prepared, it puts everyone into a better position. I'll never forget this one case. The applicant came in with an organized folder of pictures in chronological order, and I was amazed. So that allows for better affidavits to be written, to come up with better evidence, because no evidence fits one case the same way. Every case is unique, and the evidence needs to be tailored to the specific circumstances of that case. And of course, last but not least, being prepared means not going to any immigration interview or hearing without practicing. Even if it's by yourself, make sure you understand what relief you have. Make sure if it's your child, your parent, your spouse, you are practicing together. Your attorney should have you practicing, but you should be practicing on your own. Nobody will understand your immigration case better than you do. Practice answering questions about your relationship, your living situation, your travel history, and your future plans. Practice answering questions about how you met when you decided to get married and what your daily life looks like together. The more prepared you are, the more confident you will appear at your interview. And confidence is important because nervousness can sometimes be misinterpreted as deception. So in 2026, you cannot stop the changes. You cannot stop the changes, but you can control what you can control. Being prepared, having the right evidence, knowing your case better than anybody else, those are some of the major things that you must get right in 2026. The immigration landscape is shifting, but opportunity still exists. Green cards are still being approved. Families are still being reunited. The American dream is still attainable, but the path has become more challenging, and only those who are thoroughly prepared will successfully navigate these challenges. Make sure you subscribe to US Policy Brief and hit that notification bell so you never miss an important immigration update. Share this video with anyone who might be affected by these changes. The more people who are informed, the better prepared our community will be to handle whatever comes next. If you have questions about your specific situation, drop a comment below. I read every single one and will do my best to provide guidance. However, remember that every immigration case is unique, and if you have complex circumstances, consulting with a qualified immigration attorney is always the best approach for personalized advice. Thank you for watching US Policy Brief. Stay informed, stay prepared, and remember that in 2026, preparation is not optional. It is essential. I'll see you in the next update. Take care and good luck with your immigration journey. These are massive immigration changes in 2026 for green card holders, and now you are equipped to face them.